Comments in at 8:30, so they are probably assembling as we speak, but this gives us some extra time to wrap up some of our work. I do have, with care and caution, act with judgment, reason, and all right, the objections noted. I am declining the request for the modification. Again,
Are you single? Maybe you're divorced or new.
Standard language from the jury instruction.
If a man wears this, he's definitely getting lucky tonight.
Most jeans are either super baggy, too stiff, or
for them, not in
reason to believe
for present. First, Mr. Miu intended to
but for outside circumstances. Some of you may have wondered why we called Marion Davis. AJ certainly wasn't for his eyewitness testimony. He would have died took the blood in the helicopter video. He would have died. He took a video that captured Dr. Meyer. He is lucky.
Mr. Miu's life experiences dealing with the traumatic events on July 30 were relevant. So I limited the scope of the inquiry to the fact that Mr. Miu was having nightmares, that they were about July 30, 2022, and that he sought out treatment or counseling for them. I did not allow the defense to get into what the medical treatment was, including prescription medication that he may have been given. I also instructed the state that given the objection and given my ruling, that the state would not be permitted to make arguments that Mr. Miu's experiences should be discounted because there's no evidence of a medical provider, a psychiatrist, psychologist, or prescription medication because they had objected to that evidence. So that's my summary. If anybody wants to add to it, you may do so.
That's my recollection, Judge.
Yes, Judge, just to make it clear, I wanted to, as an offer of proof, I wanted to ask Nicolae about how his body responded to those nightmares. That is, when he woke up, what was his body feeling? Was he chills? Did he have sweat? Was he shaking? If I had asked those questions, I would anticipate that he would have told me all of those things would have existed. I again think that that would further support his claim that the nightmares were real. Secondly, I wanted to ask him about the treatment, and I expected him to testify that yes, he saw a doctor and a nurse, mostly a nurse in the jail, and that he received a prescription for prazosin, which it's his understanding and confirmed by my research that that is a prescription for PTSD related nightmares. And so again, as you're somewhat articulated, it's our position that if the state affects his taxes credibility on that, I should be able to get that into evidence. It's our position that since they're attacking his credibility in general, anytime I can have his credibility supported on relevant matters, I should be allowed to do so. Your Honor gave a ruling that Your Honor articulated.
Right. And the attorneys do have the ability to rehabilitate the credibility of their witnesses. I just put limits on the extent that we were going to go into it. That's largely how I arrived at my ruling. I'll also note too that we've had a number of other sidebars where we didn't make records. Everybody has the opportunity to make a record if they feel one is necessary. It's been my recollection that most of these substantive rulings have had records made in close proximity to the time of the sidebars. Others, I may have made rulings on form questions, foundation questions, given the attorney's direction to move in a different direction or approach a problem from a certain perspective. I don't think they were substantive in nature. It was more technical. I think some of the other sidebars had to do with the attorneys putting me on notice about things that are likely to occur or may happen. But I don't remember any other sidebars that involved the inclusion or exclusion of meaningful substantive evidence over the objection of one of the parties. Anybody remembers something that they want to make a record of, you have an open invitation to do so. I also want to circle back to exhibit number 24. Yesterday there was a request to seal a trial exhibit. Neither of the attorneys have provided me with any law authorizing it. And unless you do so now, I conclude that you still do not have supporting authority. As a judge, I
believe yesterday I articulated, I think exhibit number 24, I would just note chapter 950. I appreciate it's probably not my space to make that argument, but I will nevertheless. Chapter 950 involves the dignity of human beings, particular victims, and in my opinion, the photos, I think we're talking about the photos.
Yes.
Those photos being made public is contrary to respecting the dignity of those people that have that right.
I understand the thought and the sentiment. In a way, as a human being, I agree. However, as a judge, I have to follow the law when it comes to sealing records. And judges are very restricted, at least in Wisconsin, about what records can be sealed from the public. And the authority is defined specifically by statute. Things like juvenile records, trade secrets, social security numbers, pre-sentence investigation reports, psychological studies. Things like that are all defined in statute that a judge either is permitted to or is required to seal. judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on Exhibit 24. I provided the attorneys with a printed version of all of the proposed verdict forms. Did anybody have any objections?
No.
I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes. All right, let's table the sidebar for a moment. I want to get these jury instructions done so I can have them printed. We left off at 1072, the attempted crimes for counts 2 through 5. Mr. Nelson, you had a lot of objections yesterday that applied to 1017. Those same objections would apply to 1072 because same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge. In 1017 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide or mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second was to make sure and clear that the burden is on the state is in direct contradiction to the state v. Austin 349 Wisconsin 2nd 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on paragraph 7, mentioning the jury instructions, and Austin said, however, there was no mention of the burden of proof relative to self-defense. He talks about that in the context of recklessly endangering safety. And then later on page 17, it talks about the standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20, we're discussing the second degree reckless homicide and the second degree recklessly endangering, that Your Honor had the words that I believe were added in other aspects, and that Mr. Miu was not acting lawfully in self-defense.
All right, the objections noted. I am declining the request for the modification. Again, this comes from the pattern standard language from the jury instruction book, authored by the jury instruction committee. It's a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue the respective points, including the importance of the self-defense being disproved by the state beyond a reasonable doubt. What's next?
That was the only additional request after reviewing the instructions, Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to additional instructions that you think, additional or removal of instructions. Is there any changes, objections, concerns that you have to the jury instructions as presented?
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time, and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346 Wisconsin 2nd, 289. It could If there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And two, whether there's why this is the appellate review standard, if there's prejudice as a result.
Which juror?
40-21.
Judge, we don't agree. I'm not looking at them, so I don't agree with the factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat in the witness chair. Mr. Anderson.
You've already testified, but can you please state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions.
What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer?
About an hour.
And she was dozing off and appearing to startle awake?
Yes.
Multiple times?
Yes.
And from reviewing our jury list in our office, we believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson.
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross-exam?
It would have been during her direct exam.
And that was the before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video.
Was it at any time other than during the playing of the video?
Not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes.
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video?
I believe so, yes.
Was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is, fair to say, rough?
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was correct. It was only during the playing of the video.
Correct.
And it was only during a portion of the playing of the video.
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment, or would that last for 10 minutes, or you don't know?
I was out watching her over 10 minutes, so I would say a moment.
Okay. So her chin would go down for a brief moment, and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed, and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
Well, I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back, and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning
continuous? No, sir.
All right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes. You can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
Okay. And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
Would that be a fair estimate?
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes.
You agree with that?
I do agree.
Nothing else.
Jameson?
So the 4 or 5 times, is that when you saw the head jerk?
It was both. At times I would look over and she just chin down, eyes closed, and then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
Were there, when you looked over, if you recall, was it one of those 2 states, or were there several times where you looked over and she did appear to be alert?
Those were the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling awake?
Yes.
Nothing else?
You said it was only during the playing of the video. Agreed?
Yes.
You understand that the video was less than an hour, correct?
Approximately an hour, yes, sir.
It's about 50 minutes.
Yes, sir.
So based upon that,
you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record,
56 minutes.
it wasn't over an hour. Agreed? Yes, sir. And you can't tell the judge during those 56 minutes when you made the first observation. Agreed? Agreed. So you don't know if it was 15 minutes into the video, 30 minutes into the video? You can't say. I cannot give you an exact time, no, sir. And all you do is, you said you saw it about this 4 or 5 times, correct? Correct, yes, sir. And you're not in a position to say whether her head was down for any continuous period of time. Agreed? Agree. That's all, Judge.
Thank you, Detective.
Thank you, Judge.
Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial with an attentive jury. So I think I ask that the court strike juror 4021 as one of the alternates.
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree. That there are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding. I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point too is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room.
How's it going? I appreciate you coming by. Definitely let me know your opinions. If you feel like this guy's guilty or not guilty, please let me know down in the comments below. But I appreciate you for stopping by.
Room has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
No.
All right. Anything else from the defense?
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
All right, looks like they taking a little break. Let me see if I can fast forward so we won't have to sit here and wait. All right, let me fast forward a little bit right here.
Deliver the jury instructions, and then the attorneys will make their closing arguments. Here's how the day will work. I will deliver the jury instructions to you. That'll take some time. I will have them displayed up on the board so you can follow along, but I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Trofsky will deliver Mr. Miu's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Miu is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nicolae Miu committed crimes in St. Croix County, Wisconsin on July 30, 2022.
Which he did.
An information is nothing more than a
criminal.
written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Miu in any way. It does not raise any inference of guilt.
He's guilty.
In count 1 of the information, Nicolae Miu is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Miu is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime. Both intentional and reckless homicide require that Mr. Miu caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that Mr. Miu acted with intent to kill. First and second degree reckless homicide require that Mr. Miu acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Miu reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Miu had the opportunity to retreat with safety, whether such retreat
Of course
was
he
feasible,
did. He had all the
and whether
opportunity
Mr. Miu
to back up
knew of the
and run
opportunity
away.
to treat.
But no, he
knew of the
decided to stay
opportunity
there.
to retreat.
The dude literally decided to stay there, like, and argue with these young adults. Like, I swear, if the jury does not find this dude guilty, I'm gonna be so triggered. Y'all are gonna see me just like rage quit. I swear. But I see that somebody else joined. Definitely let me know how y'all feel. down in the comments below about this whole case, all right?
You should also consider whether Mr. Miu provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force
I would love to see them
intended or
prove that.
likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Miu is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was
Don't tell me
necessary to
this is a
prevent
case
imminent
of
death
I'm
or
white and
great
I say
bodily
so.
harm to himself.
That's what it sounds like.
Mr.
Well,
Miu
dude
is
is guilty
guilty
as
of
hell.
second-degree intentional homicide if he caused the death of Isaac Schuman with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable.
It was extremely unreasonable. He stabbed 5 people.
Mr. Miu is guilty of first-degree intentional homicide
Yes,
if
he
he
is.
caused the death
He's
of Isaac
guilty.
Schuman with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty
The
of
dude is
first-degree
guilty
reckless
as hell.
homicide if he caused the death of Isaac Schuman by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life.
Which you did.
Mr. Miu is guilty of second-degree reckless homicide if he caused the death of Isaac Schuman by criminally reckless conduct. You will be asked to consider the privilege of self-defense in deciding whether the elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding of whether Mr. Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. If the state does not satisfy you that those
I
facts
promise.
are established by the evidence,
Don't make me
you will
rage
be
quit today.
instructed to
Do
find
not make
Mr.
me
Miu
rage
not
quit.
guilty. The
Let's
facts
see what these
necessary
white
to
folks saying.
constitute each crime
Let's
will
see if
now be
they
defined
support
to you in greater
terrorists.
detail. First-degree
Come on,
intentional
white people.
homicide,
Come
as
on, white
defined in
people.
Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find Mr. Miu guilty of first-degree intentional homicide,
What?
the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Miu caused the death of
Oh
Isaac
my
Schuman.
God, bro. They're not tricking me. This
The word
nonsense.
cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu acted with the intent to kill Isaac Schuman. Third, Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The words intent to kill means that Mr. Miu had the mental purpose to take the life of another human being
Yes, he did.
or was aware that his conduct was practically certain to cause the death of
He
another
pulled
human
out
being.
a pocket knife and cut upwards.
While the law requires that
Right.
Mr. Miu acted with intent to kill,
Oh my
it
God,
does not
bro.
require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day,
Oh my God, bro.
an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all,
Bruh.
from Mr. Miu's acts, words, and statements.
He
if
literally
any,
washed off his
and from
hands
all
and
the
then hit
facts
the
and
weapon and then
circumstances in
changed
this
clothes.
case bearing upon intent. Intent should not be confused with motive. While
What?
proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove Mr. Miu's motive.
That's that
in order to
bullshit
convict.
terminology that they be using.
Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves.
Come on, white
under
folks,
all
please have some sense
circumstances.
today. Please, white folks, wake up with some damn sense today.
The third element of first-degree intentional homicide requires that Mr. Miu did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, one, that Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or two, that Mr. Miu did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Miu's belief is not an issue. You are not to be concerned. I'll start over. You are to be concerned only with what Mr. Miu actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Miu is guilty of second-degree intentional homicide.
Okay.
If you are satisfied beyond a reasonable doubt that Mr. Miu
This
caused
dude
Isaac
is guilty.
Schuman's death
For sure.
with the intent to kill, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However,
Like this
if after full and complete
54-year-old
consideration of the
dude
evidence,
killed a
you
17-year-old.
conclude that further deliberation
Because they were trying to
will
have
not
fun.
result in unanimous agreement
Like,
on the
this shit is
charge of
crazy.
first-degree intentional homicide, you should consider whether Mr. Miu is guilty of second-degree intentional
Guilty
homicide.
as hell. Dude is guilty as hell.
Before you may find Mr. Miu guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu caused the death of Isaac Schuman. Second,
Which he
Mr.
did.
Miu acted with the intent to kill Isaac Schuman.
Which he did.
Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in the circumstances of Mr. Miu would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in the circumstances of Mr. Miu would not have believed he was in danger of imminent death or
54-year-old
bodily
would have
harm,
walked away.
or 3, that a reasonable person in the circumstances of Mr. Miu would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself.
That's still guilty as hell, bro.
A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Miu's position, under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Miu's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person,
this guy, Nick,
did not
is guilty.
reasonably believe
the
force
I
used
swear
was
these white folks
necessary
better
to
have some
prevent
sense
imminent
today.
death or great bodily harm to
Y'all
himself,
better have some sense,
you
man.
should find Mr. Miu guilty of second-degree intentional homicide.
Dude, guilty as hell.
If you are not so satisfied, you must not find Mr. Miu guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a
Reckless
lesser
homicide.
included offense of
Wait,
first-degree
what?
intentional homicide.
Well, no, it was intentional.
You should make
Hell no.
every reasonable effort
fuck?
to agree unanimously on the charge of second-degree intentional homicide
That shit
before
was
considering
extremely
the offense
intentional.
of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree reckless homicide.
Dude, guilty as hell, bro.
First-degree reckless homicide, as defined in Section 940.02, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter
These white
disregard
folks
for
better
human
have some
life.
sense today.
Before you may find Mr. Miu guilty of first-degree reckless homicide, the state must prove, by evidence that satisfies you beyond a reasonable doubt, that the following 3 elements were present. First, Mr. Miu caused the death of Isaac Schuman.
Which he did. Did he not? Did he not cause the death?
The word cause means that Mr. Miu's act was a substantial factor in producing the death. Second, Mr. Miu caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an
Oh my
unreasonable
God,
risk
bro.
to another.
Don't trigger me today.
If Mr. Miu was acting lawfully in
Do not
self-defense,
trigger me, bro.
his conduct
Do not
did
trigger
not
the trap
create an
card.
unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable.
Oh my God.
The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life.
Which he did.
In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing,
What factors?
why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Miu's conduct showed utter disregard for human life.
As he did.
Consider also Mr. Miu's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide.
Which I find him
If
guilty.
you are not so satisfied, you must not find him
I
guilty
find
of
his
first-degree
ass
reckless
guilty.
homicide, and you should consider whether he is guilty of second-degree reckless homicide,
Oh my God.
which is a lesser-included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Miu is guilty of second-degree reckless homicide.
This is so annoying. Just fucking lock his ass up, bro. That's all y'all gotta do. Y'all ain't gotta go through all this shit.
Second-degree reckless homicide,
Just lock
as
this
defined
dude
in
up.
section 940.06 of the Criminal Code of Wisconsin,
Lock and dude
is
up.
committed by one who recklessly causes the death of another human being.
He
The difference between
doesn't deserve a
first
fair trial.
and second-degree
Look
reckless
at him.
homicide
Look at his
is
hair.
that
He's a
first-degree
criminal.
offense requires proof of one
Clear
additional element,
thug.
that the circumstances of Mr. Miu's conduct showed utter disregard for human life.
This dude is a thug. Look
If
at
you are
his hair.
satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the
Only
conduct
thugs
showed utter
switch back
disregard for human
their hair
life,
like that.
you should find Mr.
That means
Miu
he's in
guilty
it.
of second-degree reckless homicide.
That means that he's in
In
the
other words,
gang.
If you are satisfied beyond a reasonable
Gang
doubt
affiliated.
that Mr. Miu caused the death of Isaac Schuman by criminally reckless conduct, you should find him guilty of second-degree reckless homicide.
Guilty
If
as
you are
hell, bro.
not so
Lock his ass
satisfied,
up.
you must find him not guilty. You are not,
Throw away
in
the
any
key.
event, to find Mr. Miu guilty of more than one of those foregoing offenses.
Throw away the goddamn key.
Mr. Miu is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Miu is guilty of attempted first-degree intentional homicide.
Bro, buddy guilty,
If
man.
you are not satisfied that Mr. Miu is guilty of attempted first-degree intentional homicide,
Dude
you must
is
consider
guilty as
whether or
hell.
not he is guilty of attempted second-degree intentional homicide.
Why are my damn titles up there? That's so annoying.
Or first-degree recklessly endangering
Ready?
safety,
Guilty.
or
He's a
second degree
thug.
recklessly
Lock him up.
endangering safety,
Lock him up for good,
which are less
guys.
serious degrees of attempted
Go away
criminal
the key.
homicide.
He's a thug. Lock him up.
The crimes referred to as attempted first
Lock 'em
and
up.
second degree intentional
Lock his ass
homicide
up.
and first and second degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second degree intentional homicide require that Mr. Miu intended to kill another person,
Which he did.
and Mr. Miu did acts toward the commission of that crime, which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor.
Dude is guilty. Lock him
First
up.
and second degree recklessly
Lock
endangering
his
safety
ass up for good.
requires
Throw away
proof
the
that
key,
Mr. Miu
man.
recklessly endangered the
Throw away
safety
the
of another
goddamn
human.
key.
First degree recklessly endangering safety requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Miu has committed. For count 1, you were instructed on the law of self-defense.
Away the key.
The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved, in this case,
Throw away the key.
the effect of the
He's
law
guilty.
of self-defense is as follows.
He's a criminal. He's a thug. Nick is a terrorist thug who belongs
Mr.
in
Miu
jail.
is not guilty of either attempted first or second degree intentional homicide or first or second degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself.
Not only to
Mr. Miu is
himself, to
guilty
everybody
of
else
attempted second degree
who's out there, the
intentional
5 other
homicide
people.
if he actually
Asshole.
believed the force used was necessary to prevent imminent death or great bodily harm to
I
himself.
swear, if these white folks
but
don't
the
have no
belief
sense today, they're going
the
to trigger
amount
me.
of force used
They
was
better make the right
unreasonable.
decision.
Mr. Miu is guilty of attempted first degree intentional homicide
Exactly, he's
if he
guilty.
did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Miu is guilty of first degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Miu is guilty of second degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr.
Hey, make sure y'all vote on a poll whether y'all feel like he's guilty with a lesser charge, not guilty, or do y'all think that this is going to be a hung jury? Please let me know on the poll. Let me know how y'all feel about this down in the comments.
Miu acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Miu not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Miu guilty of attempted first-degree intentional homicide,
Guilty.
the state must prove by evidence that satisfies you beyond a reasonable doubt that the following
Effing
three
guilty,
elements
man.
were present. First,
Lock this
Mr.
thug
Miu
up.
intended to kill the named person.
Which he did.
For count 2, the state must prove Mr. Miu intended to kill Alexander Martin.
Which he did.
For count 3, the state must prove that Mr. Miu intended to kill Dante Carlson.
Which he did.
For count 4, the state must prove that Mr. Miu intended to kill Anthony Carlson.
Which he did.
For
Massacre.
count 5, the state must
Complete
prove
massacre.
that Mr. Miu intended to kill Riley Madison. Intent to kill means that Mr. Miu had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being.
I mean, dude was sober as hell.
The second element, Mr. Miu
The young
did
adults
acts
were drunk.
which
So he was in a
demonstrate
clear state of
unequivocally,
mind.
under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Miu's acts under the circumstances. Another person means anyone but Mr. Miu and may include the intended victim. An extraneous factor is something outside Mr. Miu's knowledge or control.
God. Oh my God,
The
they're
third
stressing me out. They
Mr.
stressing me
Miu did
out.
not actually believe
These white folks
that
better
the
find
force
him
used
guilty.
was
I swear to
necessary to
God.
prevent imminent death or
I
great
swear
bodily
for
harm to
Jesus.
himself.
Well, for
While the
Jesus.
law requires that Mr. Miu acted with intent to
Find
kill,
this thug
it
guilty.
does not
Lock
require
him
that
up.
the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent.
Yes, you
Intent to
can.
kill must be found, if found at all, from Mr. Miu's acts, words,
Who is
and
breathing
statements
on the
if any,
mic? Oh my
and
God,
from
bro.
all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Miu's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Miu did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Miu did not actually believe the force used was necessary to prevent imminent death, or 2, that Mr. Miu did not actually believe the
Bro,
force used
if y'all
was
keep reading
necessary
all
to
this
prevent
bullshit,
imminent danger of
just
death
lock his ass up
or
before he
great bodily harm to
he
himself.
decides to stab somebody else. If I can see him getting angry,
When
look at the back
attempted
of his hair
first-degree intentional homicide is
standing
considered,
up. You know,
the reasonableness of Mr. Miu's belief is not an issue.
y'all see that right there?
You are to be concerned only with what Mr. Miu actually
He's
believed.
getting mad. He's getting mad.
Whether these beliefs are reasonable
He's about to
is
stab
important
5 other
only
people
if
right
you
now.
later consider whether Mr. Miu is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named
Which he did.
person, except for the intervention of
did.
another person or some other extraneous factor, and that Mr. Miu did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted first-degree intentional
Guilty as hell.
homicide. If
Guilty.
you are not so satisfied, you must not find him guilty
Oh
of
my
attempted
God.
first-degree intentional homicide, and you must consider whether Mr. Miu is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide.
We don't need to know all this. He's guilty, okay?
However,
oh my God.
If, after a full and complete consideration of the evidence, you
This
conclude
thug
that
is
further
completely
deliberation
guilty, all right,
would not
guys?
result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Miu is guilty of attempted second-degree intentional homicide.
This thug is guilty. Throw away the key.
Before you may find Mr. Miu guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present.
Lock his ass up. Good man. Lock his ass up.
First, Mr. Miu intended to kill the named person. Second, Mr. Miu did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person,
Yep.
except for the intervention of another person or some extraneous factor. Third, Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person,
Oh my
or did
God.
not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally,
I mean,
another
yeah,
person,
you've been talking for
and
like 8 hours,
extraneous
bro.
factor. Use the
Everybody's
same-
ready to send him
same
to jail
definitions apply
before
to
he
your consideration of
stabs
attempted
5 other
second-degree
people.
intentional homicide. The third
Goddamn,
element
Judge.
of attempted second-degree intentional homicide requires that Mr. Miu not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or
Oh my
great
God.
bodily harm to himself. This requires that the state prove any one of the following. One, that a reasonable person in Mr. Miu's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person. Or two, that a reasonable person in Mr. Miu's
Lock this
circumstances
thug up.
would not have believed
Lock his ass
he was
up.
in danger of imminent death or great bodily harm. Or three, that a reasonable person in Mr. Miu's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Miu's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Miu's position under the circumstances that existed at the time of the alleged offense.
Clearly guilty.
The reasonableness of Mr. Miu's beliefs must be determined from the standpoint of Mr. Miu at the time of his acts and not from the viewpoint of the jury now.
Oh my God. If y'all don't hurry up and quit delaying this dude's imminent demise.
If you are satisfied beyond a reasonable doubt that Mr. Miu intended to kill the person named in each count,
Which it is.
Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Miu's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Miu did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Miu guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Miu is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser-included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Miu is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Miu guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Miu endangered the safety of another human being. Second, Mr. Miu endangered the safety of another by Mr. Miu endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Miu was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Miu's conduct created an unreasonable risk to another. If Mr. Miu was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Miu's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Miu was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the
What's going on? Looks like voted in them left asshole.
Conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Miu's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Miu's conduct showed utter disregard for human life. Consider also Mr. Miu's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt
I'm
that
not
Mr.
satisfied,
Miu
especially
recklessly
with you talking the
endangered
whole
the
damn
safety of
time.
another,
Definitely not
those named in
satisfied.
each count: Alexander Martin for count 2,
White
Dante
triggered, if you
Carlson
ask
count
me.
3, Anthony Carlson count 4, and Riley Madison count 5. And the
Pretty much
circumstances
triggered.
of the conduct showed utter disregard for human life.
Oh my God.
You should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Miu is guilty of second-degree recklessly endangering safety.
Buddy is guilty.
Second-degree recklessly endangering
as
safety,
charged.
as defined in Section 941.30, Parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element: that the circumstances of Mr. Miu's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Miu guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Miu endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety.
Bro, how many times are you just gonna like repeat the
satisfied,
same fucking shit?
you must find him not guilty.
Oh my god, I'm getting triggered.
You are not, in any event, to find Mr. Miu guilty of more than one of the foregoing offenses for each count. Yes, please take the jury out.
All rise for the jury.
I'm getting triggered. I'm getting triggered.
Let's return in 5 minutes, 9:40.
Oh my god, they about to take another goddamn break.
No,
These white folks better hurry up. They better lock his ass up. These white folks better lock his ass up, man. Well, it looks like they're about to take a break, guys. Fucking assholes.
I think I speak for everyone in the courtroom. That was a well-timed break. All right, is everyone ready to listen to the judge talk some more? All right. I'm picking up on page 20. In count 6 of the information, the judge alleged that Mr. Miu committed battery. Battery, as defined in Section 940.19, Parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Miu guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following four elements were present.
Judge, can we approach quick?
Yes? Every lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Miu committed battery. So let me get to the elements. First, Mr. Miu caused bodily harm to Madison Cohen. The word cause means that Mr. Miu's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Miu intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Miu had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Miu caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Miu knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Miu's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Miu did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all four elements of battery have been proved and that Mr. Miu did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Miu committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Miu guilty on any of these counts, you must answer the following question. Did Mr. Miu commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Miu committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Miu is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Miu is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Miu's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Miu the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Miu the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts, according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Miu committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Miu's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafazi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge. Absolutely senseless and horrific acts of violence. And all Nicolae Miu had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state. Objection.
Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they're calling Nicolae. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nicolae did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends, recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nicolae would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nicolae is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly wasn't for his eyewitness testimony.
I am surprised my results look like this at 64.
What we're doing today is we're going to use a scanner to measure your body fat, basically your overall body composition. What's happening right now is it's sending multiple electrical currents through your body, and this gives us a good idea about what's been going on since you started this big change. I'll go get the printout, and then we'll go over your results.
All right. Wow, I did not expect my results to look like this at 64.
I mean, I think it's
to see, you can see enough. And it shows Nicolae seeking Dante out and stabbing him when his group is in the opposite direction. Nicolae walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
We have the screen, please. So here at 2 minutes and 6 seconds, this is after Nicolae has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nicolae's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nicolae until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nicolae was doing at this point, even though this video didn't. And here, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nicolae, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Well, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nicolae admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nicolae, dark swim trunks, bigger build. On the right, you can see Dante. Swim trunks, lighter on top, darker on bottom. You'll see Nicolae walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex bang. We'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nicolae and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nicolae, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. Makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nicolae's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what's going on the whole time. She was completely sober. You heard her testify, Nicolae punched Madison. She has zero connection with the group anymore, zero contact. Her equipment broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nicolae towards Nicolae's group. Nicolae turns and stabs him twice. Another one I submit to you is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nicolae to leave. In the middle, when Nicolae turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nicolae, Isaac is just standing in the background. He's not saying anything, he's not doing anything, he's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nicolae smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nicolae never said anything about being choked, never said anything about pain on his neck, even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nicolae has just stabbed Riley, who you heard from multiple witnesses who are just standing there. Tony comes to try to break it up. Nicolae stabs him twice. Isaac, just off frame, I submit to you, he just saw Nicolae stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nicolae. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nicolae's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Let me take the screen down. I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nicolae stab 2 people who posed no threat to Nicolae. Tony was breaking up the fight. He had actually ignored Nicolae at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13-on-1, 13-on-1, implying it's some sort of mob beating up Nicolae. It's not even 13 people yelling at Nicolae. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity.
They're supposed to be deciding if this dude is guilty or not. And he's obviously guilty as hell. But they're trying to like make it seem as if like it was like a 13-on-1 fight.
He ran up on the board.
Which is complete bullshit.
And others multiple times. Even at worst, this is a 2-on-1.
Yeah.
With AJ and Dante. But
That dude is really trying to like.
It's more like a 2-on-2. Ariel's right there.
The dude stabbed him and like
Neutral party to separate things.
gutted him.
It's not 13.
Like had to do fucking intestines and shit hanging out. Like that's just fucked up.
As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife.
That shit crazy. Because the kid was only 17 years old. 17 years old, man. That shit crazy.
Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please.
They was out there chilling, having a good ass time.
This is the second time you saw in the video that Nicolae turns his back on the boys. And people.
Exactly.
You don't turn your back on somebody.
What you gonna do? Like punch a little kid in the mouth? Like.
Don't turn your back on somebody if you're afraid of them. Especially if you're so afraid you gotta.
That shit crazy.
You can't be that afraid that he's got a.
Like whatever happened to that saying? Sticks and stones can break my bones, but words can never hurt me. Like
angry.
that dude, fucking pulling out a goddamn knife over words.
Only less than 30 seconds after he turns his back.
That dude is crazy. He got drowned in 2 feet of water.
The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Ryan. He was getting pushed.
Yeah, no, the people that trying to justify that he's innocent are just pure evil. Like
they're not in
they're
his
just full
face.
of shit.
You can see in the images they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him.
That dude went up there with a damn fucking knife, acting all mad and shit.
I'm going to back up a little bit and talk about Nicolae looking for the fall. So Eric Von Williams from Nicolae's group, you heard testify.
Well, I don't know, just like I said, some people, some of them old white folks should be waking up mad. Should be waking up mad at the damn world. Like,
Ernesto told Nicolae not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nicolae went. Sandy said he went twice.
Yeah, because he's going to end up snapping on somebody else.
Over by the boys. Defense argued
Just like I was joking around saying that they need to hurry up and lock his ass up before he stabs somebody in the courtroom. Like,
clearly he wasn't looking for little.
he probably got a pocket knife on him right now.
But the boys are not completely unreasonable.
Like, these are fucking psycho.
They reacted wrong, but they just didn't invent this whole thing in order to humiliate.
Then like the whole incident afterwards, baby. Like the dude literally washed off his knife, tossed it into the bushes, and then like went back to his crowd, and then didn't even let like his group know what was going on. They didn't even know what was going on. And then like even when the cops came, like they ain't say nothing to the cops. He just walked right past them. Then he gonna try to change his whole outfit. Like the dude is completely guilty, but I don't know. Hopefully these white folks in the jury got some damn sense today, cause they better find this ass guilty. Shit crazy.
What about Nicolae? 52 years old, apparently sober, according to I think what defense will argue. He didn't have any signs of intoxication when law was in contact with him, but he certainly made a point of telling Lieutenant Hart multiple times.
After just floating in the damn river. That shit crazy.
He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nicolae has to do is stand.
That's all I'm saying, cause like they basically saying that he like cut up through his.
They're down in their tubes.
Yeah, cut up through his
touches his knife,
chest cavity.
Runs up to them. You heard Nicolae's ridiculous
That dude is a hoe.
explanation for why he ran up on the boys. Because one was holding a phone. He thought it was Ariel's phone. You also heard Nicolae had to concede, had to admit that pretty much everyone on the river had those phone cases.
That dude is a hoe. And then people really trying to justify it by like, oh, they shouldn't have been antagonizing him. Like what? Like, oh, grown ass man who was sober at that point, wasn't even drunk, so he had a clear state of mind.
He had a surgery a couple years ago, recovered in a few weeks.
Right.
Maybe things took him a little longer than they did before. He wasn't feeble, according to Ernesto. You heard Ernesto when he was being asked about the stabbing.
This ass should not be
He's a big guy.
released anywhere in
the
public.
Army. He doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water.
Yes.
He leaves behind a devastating.
All right, like he gonna go up there and grabbing on him.
Slices clean.
That's all I'm saying. Like the first dude should have just fucking punched him in the damn face for even grabbing his leg. Should have punched his old ass out.
While defense tries to
He's a weirdo.
argue that Nicolae is this feeble old man, they ignore that the only two people actually standing close to Nicolae are these two females that are barely over 100 pounds.
Don't get hurt. So that means he must have been wiping the blood off the
If the boys are a threat, why does Nicolae run up?
Yeah, no, he had rinsed it. He had rinsed off his knife in the river.
When he ran up on them,
And then he gonna throw it in the
standing
bushes.
over them, they did nothing. They didn't kick up at him. They didn't punch
The
at
dude
him.
was
They jumped
guilty.
out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent.
Or you would have just been like, how he's saying in trial right now, like he should have been like, oh, you know, these guys were attacking me or whatever. But he ain't say none of that shit.
10 out of 10 fear, he's got to take out his knife.
He ain't say none of that. All of a sudden he's saying it in court.
What I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nicolae, the demonic look on his face, staring through people, smirking. The defense argued an opening to slide into it there.
Yeah.
Sometimes it's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nicolae, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nicolae was angry. He wasn't afraid.
Yeah, that dude was pissed off. Because that's why he punched that lady in the face like for coming up to her.
Why didn't he just walk away?
Because she was trying to tell his ass to walk away.
Tried to argue there's rocks unstable.
So many people are telling him just to walk away, man. You want to stand there and try to argue with these
Why didn't he just
people.
hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nicolae punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nicolae just held up the knife. Instead of opening it, down.
That's all I'm saying. I'm sorry, like,
because it's human nature.
I would get contempt of court so fast because I don't see how they just sitting there looking at this dude in trial. I would have hopped over that damn bench so fast. I'm like, you got me fucked up.
In that situation, they were truly unfair of their life or great bodily harm.
I was gonna say I'm traumatized. Shit.
So let's talk. Here's Owen reacting. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk.
Hey, I appreciate y'all for joining in the video. Please drop a vote in the on the poll whether y'all think he's guilty or not, and let me know what y'all think about this in the chat. All right.
Talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nicolae punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet. She didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nicolae, she gets punched and falls backwards, and then their attention's back to Nicolae.
Oh my God, about that.
Because Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nicolae before the camera pans away. When the camera pans back, now Dante's shoulder
You said what, baby?
Riley.
You said what, baby?
Back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nicolae got punched. He didn't have any injury. Defense can't have it both ways. So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nicolae did. Defense has tried to highlight throughout the trial, Nicolae was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who's disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nicolae, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nicolae punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and, say, your partner go to the grocery store. Park your car, you're leaving the grocery store. You think your car's parked over there, they think it's parked over here. You still know the car's parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the boys group, that Nicolae struck Madison.
Exactly. And people over here trying to say, oh, he ain't punched that lady. Like, what? Like, this dude got fucking problem.
So what
yeah,
about,
exactly.
Let's talk a little bit about witnesses from Nicolae's group, Ariel.
And then that's what I'm saying. Like, he stabbed 5 people. What initiates somebody to stab fucking 5 people?
Can't really say how. Never
That's
said
fucking
that.
crazy,
Law
man.
enforcement. He denied even being close to Nicolae. Remember, Ariel was there when he stabbed Dante. He was right there when Nicolae stabbed right.
That's why I don't be understanding people. Like, some people are just extremely
Law enforcement
wicked.
went there with the frame of Ariel standing
Extremely
next to Nicolae when
wicked.
Nicolae has the bloody knife.
Ariel
denies
like him.
law enforcement.
But since it's not, he took because they almost drowned him with 2 feet of water.
That shit crazy.
Ernesto, at trial, testified he didn't see Nicolae get hit, just saw him.
That's what I'm saying. Like, I don't even understand why it's taking
Said
this
he couldn't
long.
remember Nicolae saying that
They should have just locked his ass up.
you saw on the body cam. He said that repeatedly. He testified.
And trying to make him look all
somebody was
innocent
walking
and stuff.
towards him, he pointed at him, get back. Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, Nicolae, get out, Nicolae walking out, and then he said, and that's it.
You can see that he
Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times. Nicolae said they took my name.
Well, no.
So, about the punch to Madison again. Sergio, he's in Nicolae's group. He had walked out a little ways. You can see him.
Yeah, no, that's what everybody else saying. Everybody like, shoot, if I go tubing, because shoot, like I done been tubing a lot of times with my friends.
Walk over to Nicolae and
But
say, go, go, go.
just like I say though, like some of these old white folks hate seeing younger white people hang out with other races. Like
From his perspective,
they can't stand that shit. They get so fucking irritated.
How could he have seen Nicolae do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nicolae just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police
All right,
she
baby.
was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nicolae's actions, whether his use of force was reasonable,
It's not a duty to retreat. What the fuck does that even mean?
you may consider whether he had the opportunity to
So
retreat
you gonna stay there and just
whether such
fucking
retreat was feasible,
instigate the damn situation and then fucking complain when somebody do
He turned
something?
his back on them multiple times facing over. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable.
Not at all.
You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as you heard from Owen that he heard.
What you do to the last macaroni?
Fall back and catch yourself.
Well, why?
Defense has to argue that they're all either lying or mistaken. All these witnesses, including Zerkin.
Yeah.
If they're lying, why would the witness say, I saw
He's so silly.
some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch?
He's so silly.
Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell.
It's all right, baby.
Before Riley
You're gonna be my little
They
chef.
obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nicolae in that half circle, proximate shape, they're all looking
Nah.
including Sergio.
It sounds like somebody outside or something.
By the group, the tubes for the crossing group. They all were wrong in what they saw.
Like girls deals were good.
You said what?
Another
so silly.
defense double standard.
You too funny.
Relatively minor.
You said who was that?
Big Joe Mike.
There's this, try to put Nicolae's group in a different category. There's drunks on the Apple River, then there's Nicolae's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nicolae was in the exact same boat they were.
Exactly. People like, oh, why are these kids drunk? And so I'm like, y'all obviously ain't never been outside before.
Been on the river before.
All right. Exactly. These kids out here having fun, enjoying
Another thing
themselves.
About the
All right.
punch to Madison.
People just crazy. People
You
are
heard
crazy.
that They didn't get to see the video before giving their statement.
They really trying to defend.
Even Jawan, who took the video, said he got,
He's damn
got
criminal.
far enough to get the screenshot, Nicolae, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nicolae got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth.
Dude was lying the whole
Video
goddamn
happens to
time.
not show the punch, but it still corroborates what all those witnesses said.
Lying about everything. I would have been like, well, let me sentence you to 20 years and sure, after 20 years, you tell me if you can recall.
It has four elements.
Sit down and think about it.
Nicolae caused the battery to Maddie, caused the injury, the harm, the pain. She testified to that.
He should get life in prison, sure.
Despite his denial, I submit to you that's clear.
Because
Punch somebody without intending
he tried to kill 5 people. I don't care what he says. He tried to kill 5 people. Like,
He knew she didn't consent. She's a
that dude is a
stranger.
fucking
Obviously, she didn't consent.
complete psycho. Like,
Punching Madison was not self-defense.
he ain't got no type of self-control.
Again, there's no duty to retreat, but you have to consider the opportunity to retreat, knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Mr. Nicolae's.
Yeah, I think.
So what is the interference at the time?
I'm hungry.
The boys are saying cruel things. Maddie and Riley are standing in front of him, lightly touching his shoulders.
Drop that vote.
People are pointing and laughing.
Drop that vote on the poll. Let me know
Maddie
how y'all
Riley
feel
are
about the
in his
case, if y'all
face,
think he's
standing
guilty or
close,
not.
Not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do. Just walk away.
Just walk away. That's all they have to
Instead,
do.
he takes out his knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nicolae essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. The jury instructs them to talk about provocation. And how that affects self-defense. Person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid.
Oh my God, if I die.
Remember, Nicolae ran up on these boys who were too below. They didn't run up on him. He ran up on them as they're two.
Yeah, he ran up on
They insulted him.
and got
He was angry.
and needed to get his ass whooped.
He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel."
Looking for a goddamn
I'll
snorkel.
play that for you so you can hear it.
But then my thing is, how the hell, if his group was way over there, like somewhere else, how you gonna try to say his snorkeler was over there by where they was? I made no goddamn sense.
This is at 105 in the video. I'm ready.
Go to the kids, go! Go! Go to the kids, go! Go! Go to the kids, go! Go! Doesn't matter. Go.
You didn't. You can take it down.
Okay, they better not show no violent shit. I ain't trying to get flagged.
He didn't go over there to actually.
I'm not trying to get in
resolve the
trouble.
situation. He went over there and accused the boys of taking the snorkel, which was a lie. And he had just ran up on the boys. So, after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nicolae gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nicolae pops right up and disembowels AJ. After Nicolae goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nicolae down on the ground, Tony walks by Nicolae with his back to Nicolae, yelling, "Get back to Dante." He turns around to tell Nicolae to get away, and Nicolae turns around and stabs him. Nicolae was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart.
Yeah, so he was walking up to people, stabbing people. Like, this dude was intentionally like stabbing people.
I submit to you, the state has proven beyond a reasonable doubt this was not justified self-defense.
And how's that self-defense if you're walking up to people,
From the moment
stabbing
you did it.
people?
First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open
That
river,
dude full of shit.
150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believed death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nicolae's intent but to kill when he slices him up like that? He had the knife blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung.
You said what?
Tony blocked one stab, so Nicolae stabbed
You said what, brother?
when he blocked his stomach injury. It was very close to where AJ's
Oh, no, it's hard to know.
artery was severed. Dante was stabbed again, just below his heart. But for Nicolae missing vital organs, but for medical intervention. Miu claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound to the torso, stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nicolae killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, missed the vital organs of Dante. But for AJ blocking one strike, missing vital organs, he survived. Nicolae said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide of Isaac Schuman, Nicolae stabbed him so hard, he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the counts. Third element, he did not reasonably believe the force was necessary. That also goes to, I'm sorry, that's part of the third element. So how do we know, what Nicolae believed? What a reasonable person would believe? That there's only one person on the planet who experienced what Nicolae experienced, saw what he saw, was standing in his place. And what did Nicolae believe? He believed it was unjustified. The very first thing he does is walk away. Doesn't run. Doesn't tell Ariel or Nestle anything. Doesn't tell them to run. He walks away from his group, to the other side of the river. At some point rinses the knife because it wasn't covered in blood. Throws the knife onto the bank before walking back to his group. Says nothing to his group other than they took my knife. Puts on his hat, sunglasses, and shirt, and sits down in his team. He's the one, as he said in his interview, says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan one, get away. Slink away with the crowd. That didn't work. Plan two, play dumb. Can you take the screen down, please? Okay.
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
Yeah.
Okay.
Somebody,
All right.
I hear somebody got stabbed, and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah,
Okay. All right.
So I don't know. Okay, well.
Did you see anybody injured?
No.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, calling each other names, but, that's, I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know. Kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure they're drunk, kids being kids. That's what he told Sheriff Coons, and he's acting like he has no idea what's going on. Clearly not in shock. You need to be down, sorry. Clearly not in shock. Clearly Nicolae knows that was not justified, and he's looking out for Nicolae. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nicolae actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Ariel's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when running up on the before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nicolae did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene of chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident, about boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when you clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nicolae was not in fear, he snapped. He was angry, and he snapped, and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? You know, what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nicolae's belief versus reasonable person. Here you know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endangering safety. Element 1, Nicolae endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions definitely define criminally reckless conduct. Creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there to utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. And he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nicolae he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nicolae knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific, they were senseless, He killed Isaac Schuman, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nicolae, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state asks you to find Nicolae Miu guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at
Dude,
11:05.
guilty as hell.
Please take the jury out.
All right, guys. I'm a fast forward it. So y'all have to sit up here and wait. Give me 1 second. One second.
Is
All right, there we go.
what happened on July 30th, 2022? Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield.
Remember, he really just said, of course they being led by black dude. He started off his shit bad. Well, anyway, y'all drop a vote. Let me know how y'all feel about the case, whether y'all think this dude Nick, this thug Nick is guilty or not. Please let me know.
Saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator.
Oh, they called him names. Oh,
Purpose.
they made a funny one.
They're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson.
Oh, all these gangs being led by gang members.
6 drunk teenagers quickly turned into 13.
Oh.
13 against 1. They got in his face. They screamed at him.
Oh.
They called him names. They
Oh.
swore at him. They put their hands on him.
Oh.
And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him.
They circled him. Dun, dun, dun.
They do this to a man who has done nothing, absolutely nothing to them.
Nick is a Christian man. He's innocent.
Then, when that man, Mr. Miu, tries to create some space between him and Madison Cohen, they pounce.
They don't punch him. He punched Madison in the goddamn face, and then they laid his old ass out, and then he claimed to be drowning in 2 feet of water.
They hit him again. They choke him from all directions. And Nick Miu
Choked him from all direct. Wow. This dude reaching so bad.
That's what happened
This dude is reaching.
on July 30th.
They choked him from all directions.
I just want to give you guys
Sounds like a gang man to me.
indication as to kind of where I'm going to go, and more importantly, what I think.
Sounds like it's getting kind of sexual.
When you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat. Period.
So you don't have to walk away from a problem.
In this
What?
state, bullies like Madison Cohen don't get to tell us where to go.
Call her a
Bullies
bully.
like Madison Cohen don't get to get in our face and require that we leave.
What?
That's not a requirement here.
What?
Keep that in mind.
I'm triggered. I'm so damn triggered right now. They say that this girl Madison was a bully because she suggested that this grown ass man should walk away and not engage in these young adults like trolling him. Like, but now she's a bully.
2, subjective beliefs.
Oh my god, bro.
When you're listening
Oh my god.
or contemplating the evidence and replaying it in your mind.
If y'all have ever seen my videos, by the way, this is exactly why I exaggerate so damn much on my videos. It's because people like this, because I see how people clearly manipulate media. I'm like, this shit is fucking wild.
You are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Miu. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockfield. The video perspective that the jury is required to consider it is as Nick Miu is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there.
Remember.
Nick doesn't have to prove he acted in self-defense.
Remember.
They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Miu, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part.
149.
All right, before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Miu, right? I think to a person, they testified, yeah, we were really concerned about Mr. Miu. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo
That's what it looks like to me.
of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you?
Nope, it doesn't, man.
Because
I don't know what you're talking about.
As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Miu had to do was walk away.
All he has to do is walk away.
Well,
that's all he has to fucking do, bro.
You heard from
He
each
doesn't
one
have
of
to
those
walk away.
tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen.
He doesn't have to walk away.
And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why?
So he
Because
wanted to
John
stab him.
Hatfield was recording this entire incident.
That's what it sounds like.
They wanted to see what was going to happen.
That damn thug wanted to stab him.
They're not afraid. They want to see how this is going to play out. And Jawan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which
So
one of
because
those
they want to make
things, based on
so
the evidence?
so you're arguing because they were trying to go viral, they decide to get stabbed. Okay, bro, that's a good argument.
That you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Miu's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that?
And why does that even matter? They were trolling him. It's a fucking joke, bro. My God, damn.
Every one of them who speaks to the police provides
Trolling is not illegal. Like, that does not mean
Zero.
somebody
zero mention
has a right to fucking stab you.
that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls.
Oh my God, he's taking it so literal. Oh, fucking literal.
So,
fucking jackass doesn't have a sense of humor.
what's the alternative?
Oh, stabbing people. Stabbing people is the alternative. Okay.
I submit to you that
Makes sense.
what kind of person does what these kids did to him?
What?
And what would they look like as people if all they did was pick a guy out and start to torment him?
Torment.
What do we think of people?
Torment. Wow.
What do we
That's a
think of
strong
people
word.
who call grown men rapers and pedophiles and predators for kicks?
Yes.
What do we,
Yes.
what do we
Because that shit's funny. That shit's funny as fuck.
had to come in and say that.
Like, what the fuck are you trying to get to, bro?
Don't. We know what we think of them. That's the reason they came in, and they said this to you guys under oath.
Under
They got on that witness stand and swore to tell the
under
truth.
oath.
And they told you
under oath.
he said he was looking for little girls. Well, the cops got up under oath and told you.
Oh.
No, they never mentioned that to me.
Oh.
What are the odds? What are the odds? of that
Under
actually
oath.
and nobody mentions it to the police. What do you ask?
Under oath.
Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make
Yes,
sense?
and that's exactly what he did.
He's with his wife.
His wife.
He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time.
A fine time. Obviously not, because he's
Ariel
over there
uses
stabbing
his
people.
phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you.
Makes a lot of
You get
sense.
to judge the
Makes
credibility
perfect sense to me.
of what
I believe
people
it.
have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield's looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Miu walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult.
Oh my god, why is
So
this door
he
still
heads over
fucking sealed, bro?
to talk.
Fucking annoying as shit.
And what we know is
Explore.
you can see his thumb. He's motioning back,
Explore the vault. Like, what
trying
the...
to explain
Oh,
what happened.
there it goes.
And we know that Madison Cohen, who knows nothing about what happened, zero,
Why is he so adamant on getting on fucking Madison, bro?
screaming at him.
Just like I said, most of these older white dudes, they just hate females. They just hate women. Like, and maybe they hate women because all of their women are leaving them. So I mean, that would make sense.
Believe. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So
She's queen of the river. No, she's a fucking
we
adult
know that Nick is
who's trying to assess the
uncomfortable.
situation.
So he waits for his group to come over because the state can say whatever they want. He's by himself.
Oh, he's by himself.
So-
Oh,
We know Nick does that.
oh,
We know that when Nick waves to his
oh.
group, so does Madison Cohen. But there's one big difference.
Madison is such threat.
Her group shows up. And they show up in numbers.
In numbers, so many people.
We know that the group of teens are brave.
Bro, them
And as this
Mexicans
is
better
going
shut
on,
up, bro.
they start
Oh,
taunting this
damn.
man who's done nothing to them.
Oh, that's Mexican.
We know that. We know that Riley Madison comes over and now she thinks it's necessary.
Oh my god, let me mute my mic. These fucking
Because
Mexicans
she's
are
been
fun.
anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen, pushes him, puts her hands on him. Again, he tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Miu, you got 10 seconds.
He's got 10 seconds to live.
In life, when someone tells you that you have 10 seconds, what normally comes after that?
Yes, 10 seconds? Oh my God.
I'm going to count to 3. You got 10 seconds to do it.
What's going on, bro? You said I'm the law and I say guilty. Thank you, bro. Thank you, bro. I appreciate you coming with some sense. Yes. He's definitely guilty.
Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat. Right? And if you think about it, they all blamed.
I just think it's sickening how some people are trying to justify this shit. Like, it's fucking crazy, bro.
We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds.
Oh, okay.
And why does that matter? What does...
I can't see the exhibits and step up and go over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Miu's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
Oh my God. My audio's so bad.
What is he on? Whoa! Oh God! Yeah! What are you talking about? What the hell are you talking about? Get away from us!
Like, my thing is, bro, like, why, like, stand there and entertain these drunk ass young adults? Why just sit there and get trolled? Like that shit is crazy to me, bro.
What? What's going on with your homie? He's on camera. Scripting. He's on 14. Yo, the new iPhone got that good quality. What do you say?
I didn't even realize they were playing Tupac in the background.
Yeah, what the hell?
Them boys are jamming.
Yes! Yes! culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this?
Bro, doesn't matter.
He said he was looking for little girl! He said he was looking for little girl!
All eyes on me.
Yeah! That's exactly what he said! We're not us out! I didn't have that part on camera, did I? Some young ass kid! What the hell is this guy's problem, bro? We're trying to have fun! He's gonna claim you! He's gonna claim you! We don't want this one back!
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where...
What second is that?
state
Please
is
explain your
insinuating,
bullshit,
claiming
please.
that
Let's hear
Madison
it.
Cohen
Let's hear the nonsense.
was punched. And where Nick Miu has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it said that. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman?
Oh, okay.
And threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says If I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Miu pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs.
Look at these photographs.
Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right. Wrong.
Look at these photographs.
They do a Cellbrite downloaded
They
extraction
make me
of the phone.
laugh.
Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people on whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay? Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be
Like, you know he's full of shit, bro. Dude know he's full of shit, bro. I really hope he knows that.
Where's he gonna go? So he doesn't have to go anywhere. We don't
He's
let
trapped
people
in a
dictate
closet.
what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The
How
drug
many times are you
teenagers
gonna
don't
say that, bro?
have to leave either.
Bruh, how much time
They
is you gonna say
totally
that?
could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Miu committed an unlawful conduct against Madison Cohen. provoke this attack. He wanted her to get out of his personal space. The bully
Oh,
in the room doesn't get to yell at you and tell you to leave.
oh, Madison's a bully.
Don't leave. Doesn't get to get in your personal space because you are not leaving.
Oh,
That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday. The state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Miu. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people get injured. Because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives.
okay. So now it's moving too fast.
You have to look at those 14 seconds through Nick Miu's eyes as he was standing there. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Miu was going to get the brakes beat off of him.
Oh, okay.
So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Miu was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Miu's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Miu. Nick Miu's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know. Now, Juwan Cockfield found that to be funny.
Oh my God, bro. So now it's his fault because he was laughing.
On how he thinks it's funny that Miu's getting punched in the face and knocked in the face, slapped. Okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet.
As he
backwards into
should.
the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Miu while he's still on his back, kind of on his on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper. That's what he said. He runs up from behind and shoves Nick Miu, while Dante Carlson comes in for thirds and smacks Nick Miu in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man, who had heart surgery, is terrified as to what's going on.
Okay, so now he's terrified.
We know.
He's terrified,
Well, let me
guys.
just
He's
remind you of
afraid.
this. At
He's
this
afraid
point,
for his
after
lifetime,
he's
guys.
been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right?
I mean, good job. Well, what the fuck? You're not supposed to be stabbing people.
And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Miu before Mr. Miu stabbed him,
I put
He
dumb
said-
ass shit away.
he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Miu doesn't do a thing to him. Mr. Miu doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Miu has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schuman comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Miu. And why does it matter? Why does any of that matter? Because if you find the following, Nick Miu is not guilty of all the charges, okay? If you find that Nick Miu believed that there was an imminent, unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? If he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people.
Yeah.
I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind.
I believe he lost his mind.
Engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would an ordinary person, a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay?
Okay.
Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Miu puts his hand in his head and says something like, my life is over. And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement.
Well, I would have asked her if she would ever put herself in that fucking position in the first place.
Alex Vang.
Like, what type of bullshit?
He's getting his butt kicked.
What type of fucking response is that?
Are those reasonable people? You get to decide what a reasonable person would do in that situation.
Sure.
But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schuman, and you have to find them for the others involved, okay? And the question on intent is mental purpose.
Okay.
Can you watch that video and say that Nick Miu's mental purpose is to kill Isaac Schuman? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances,
I need a new chair. My fucking ass is hurting so bad.
anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schuman? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges, with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick.
Bro, you're not about to persuade the jury. They know that this thug terrorist decided to stab 5 people that damn day.
They don't have it. Nick Miu wanted to get Isaac Schuman away from him. He didn't chase Isaac.
We cannot have people like that in our society
Isaac Schuman
getting triggered by some fucking young adults who are clearly drunk and just getting mad and fucking stabbing people. Like, that's fucking unacceptable,
in order
bro.
to convict someone of an attempt
Completely unacceptable
state must
behavior.
prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say,
Let me know if the clicking is too loud, because I'm over here playing Diablo on the side.
A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he?
Because he ain't had the time.
If you believe Attorney
He's a
Anderson,
serial
he's
killer.
alone with Dante Carlson. Why does he stab him one time?
Oh my God, these fucking Mexicans, I swear to God.
Why doesn't he
Why the fuck are they whistling?
He wants what he wanted all
Bruh.
along. To get away
About to
from
piss me off.
He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Miu believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was no outside extraneous factor, they also say might not be attempts. Take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife.
What's going on, Thunder Show? I appreciate you for coming by and placing your vote. You said this guy gutted these kids. He had room to leave, exactly. But he gets these creepy smirk on his face. Doesn't warn them. Exactly, like. And then he just starts lying to the cops, and like this dude, like he tries to hide the weapon. Like this dude is just completely corrupt.
He lies about the knife. What Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful, and that he was being attacked. Okay, that he's never wavered on that. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong. Some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Miu's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin. That has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. you should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now.
Do you feel sympathy?
For Isaac Schuman's family.
You're trying to fucking defend this motherfucker.
I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and
facts. Well, the fact shows that Nick is a fucking terrorist killer. Okay.
In terms of the burden of proof and
oh my God, this is
what the
fucking
state has to do
asshole.
is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, you say, I need a break, I need to figure this out. That's reasonable doubt. Okay. It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty.
What?
You're like, it likely is, I don't know, not guilty. If you believe it might not be.
He just wants to win. At this point, he just wants to win so he can get paid.
It's probably not self-defense. Not guilty.
Dude, guilty as hell.
All of those considerations that you would have require a verdict of not guilty.
He is guilty.
Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense.
That video
So,
says everything.
As I go to sit down, we, Attorney Nelson, Nick Miu, and I appreciate all of your time.
Thank God you're done with your bullshit ass.
The attentiveness that you give
Fucking
us.
rebuttal.
And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Miu home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
Yeah, I need to stretch. My fucking ass is hurt, man. You still up in here, Thunder Snow? Whoever's up in here, please hit that follow. Please hit that subscribe.
You just heard Mr.
Please subscribe.
Rossi say his entire defense is based on what Nick Miu told you.
Please subscribe.
Plus thoughts in his head, the beliefs in his head. What do we know about Nick Miu? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth,
Most definitely, he's a
practically
skilled liar.
since he
Most
started
definitely.
walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself. He's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things, bizarre things. Why would he say that these boys pulled his pants down? What a bizarre lie to make up, right? Why would he say that two boys pulled knives on him? He's got to say that because he knows what he did wasn't justified. He thinks to himself, if I say one boy pulled a knife, that would be good, but if it's two, that would be better. So he crafts this elaborate story. His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his answers a couple of times when he realized that what he said wasn't helpful to his defense, right? He consistently remembered details from July 30th, 2022 that benefits his defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again.
He don't remember.
Questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying.
He's a liar.
One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys. That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Miu ran up on these boys, why he grabbed their tubes, why he was groping around for their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable. Nobody's responsible for Nick Miu's choices but himself. He chose violence at every turn. There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week when he's questioning these boys, you were trying to humiliate him. You were trying to insult him. You were taunting him. He was humiliated. He was insulted. He didn't like these boys treating him like that. He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap. He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the violence before he started it. He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back at any time when she was yelling at you? No. With no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got The 6 teenage boys standing on the side by their tubes. He's confronted by the 2 girls. Everybody else is in the background. He hits Madison Cohen when he's only got 2 girls standing in front of him. After the fight, it's 1-on-1 to start. It's Dante hitting him, and then arguably 2-on-1 when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Miu continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him telling Dante, his brother, get away, get back. Mr. Miu turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere. That he was attacked from all directions. False narrative. He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right.
He punched her.
He keeps talking about how these boys wanted to make a video. Well, they were making a video. And what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on him in their tubes. Nobody laid a hand on him until after he had already stabbed a number of people. Isaac Schuman tried to stop him. He got killed for his efforts. He seems to be arguing, the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people. He calls Maddie Cohen the queen of the river, and calls her a bully, calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to protect them. You know, maybe if we had more people on the river trying to protect people, the world would be a better place. They've made, over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Miu, who, as Mr. Trofsky said, was lifted off of his feet by the punch from Dante and punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling. The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face.
What's going on?
tells
What's
a
going
different
on?
story. He has expressions
I appreciate y'all
of
for coming by.
He has expressions of, I guess, humor. He's smiling. He's smirking. Well, after he has his knife out, he clearly feels comfortable. There's no look of terror in his face at any time.
If you could, please place your vote on the poll. You know, let me know how you feel about this whole case if you've been following it. I would love to hear your thoughts. And also, please hit that subscribe button because I'm gonna start going live and covering these cases more.
He got a incision on his body from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Miu. They made a big deal about Lieutenant Hart telling Mr. Miu in the interview that she would have been scared too. Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having 2 kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too.
What is my cat over there doing?
They're arguing that he had no
asshole,
intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up, severing 2 of Isaac's ribs right into his heart. All right? If he didn't intend to kill him, why not stab him in the belly? Right into his heart. We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't attacking him. They don't explain that because there is no explanation. None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him. They've talked a little bit about extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks, putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically that Larry and Davis and his brother, we saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, you know, whenever you have an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't get killed. It's not by anything he did. He just got lucky. Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and pulling his pants down and all this other bizarre baloney. He used his intellect, because we know he's smart, to craft this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient to convince people that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No. You have my full confidence. I know you're going to return just verdict of guilty and deliver justice to Isaac Schuman and everybody else who got hurt by this man. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Miu is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nicolae Miu. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schuman, the jury finds Nicolae Miu not guilty. Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Miu commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nicolae Miu not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question.
How's it going, guys? How's my stream looking, by the way? I just got a error message popping up saying that it's 4, but now all of a sudden it says that it's excellent. I don't know what's going on with YouTube, but I appreciate y'all for joining. Please drop y'all's vote. Let me know if y'all think, if y'all feel like this guy is guilty or he's not guilty. You know, and please let me know how y'all feel down in the comments below. Also, I'm gonna start streaming these court cases more, just because I find them very interesting, to be completely honest with y'all. But please hit that subscribe. I drop a lot of videos, but I'm definitely gonna start streaming a lot more because this is actually pretty fun.
As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nicolae Miu not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Miu is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
You swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict, and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports.
Goddamn.
If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The 2 alternate jurors are Darren.
Oh, what the fuck? Oh, okay, I guess they not saying their names right now.
You may.
I don't want nobody to get dogged.
Place where you can eat it here in the courthouse. We'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise.